When a police officer looks at you while you are filming them in a public space and says, "Put that away, stop recording," or "You need to turn that off," almost every person does the same thing. They lower the phone because the officer has a badge and a uniform and an authoritative voice, because the situation already feels tense and adding conflict feels dangerous, because most people have never been told that what the officer just asked them to do is something the Constitution specifically protects them from having to do. Here is what almost nobody knows. The right to record police officers performing their duties in public spaces is a constitutionally protected activity recognized by federal courts of appeals across the United States. It falls under the First Amendment. It is not a gray area. It is not a matter of local policy. It is an established legal right that officers in the field are required to respect, regardless of whether they personally want to be recorded. When an officer forces you to stop filming, the action they just took is likely a First Amendment violation. And what you do in the seconds immediately after that moment determines whether that violation stays on record, whether it is documented in a way that holds up, and whether you have the foundation to win if this ever goes to court. Today, I am going to show you exactly what the law says about your right to film police in public, which federal circuits have affirmed that right and how clearly, what an officer can and cannot legally do when you are recording them, and the exact steps you take in the moment and immediately after to protect your footage, document the violation, and build the record that wins in court. Hit subscribe right now because this channel exists to give you knowledge that protects you in the moments where most people back down because they did not know they had the right to stand firm. Share this with one person before this video ends. Someone who has been told to stop filming by law enforcement and complied because they did not know they had a choice. Here is the reality most people are never taught. The First Amendment protects freedom of speech and freedom of the press. Federal courts have consistently interpreted these protections to include the right of private citizens to record police officers performing their official duties in public spaces. This is not a fringe legal interpretation. It is a mainstream, well-established position across multiple federal circuits. The First Circuit, covering New England, affirmed this right in Glick versus Caniff in 2011. The Third Circuit affirmed it in Fields versus City of Philadelphia in 2017. The Fifth, Seventh, Ninth, and 11th Circuits have all recognized versions of the same right. The legal consensus across the federal court system is that recording police in public is constitutionally protected conduct. The reasoning is straightforward. Police officers performing their duties in public spaces are exercising government power in a public context. Citizens have a First Amendment interest in observing, documenting, and disseminating information about how that power is exercised. The ability to record is essential to that interest because recordings create an objective record that verbal accounts alone cannot provide. An officer who orders a citizen to stop recording, confiscates a recording device, or deletes footage is interfering with constitutionally protected activity. Courts have found that such interference can constitute a First Amendment violation, giving rise to civil liability under 42 United States Code Section 1983, which is the federal statute that allows citizens to sue government officials for civil rights violations. This is the legal foundation. What you do in the moment determines whether that foundation ever becomes usable. Here is what the bad way looks like. Citizen is filming a police encounter on a public sidewalk at a safe distance. Officer approaches and says, "You need to stop recording right now." Citizen lowers the phone immediately, says, "Sorry," puts the phone in their pocket. The incident the citizen was documenting continues without a record. Later, the citizen wants to report what happened. They have no footage. They have no documentation of the order to stop filming. They have only their verbal account against an officer's verbal account. The First Amendment violation that occurred in that moment has no evidentiary foundation to stand on. Here is what the good way looks like. Same situation, same officer, same demand. Before the phone lowers, the citizen says this calmly and clearly: "Officer, I have a First Amendment right to record police performing their duties in public. I am not interfering with your work. I am at a lawful distance. I am going to continue recording." Then the citizen continues filming. That statement does several things simultaneously. It invokes the specific constitutional right by name. It preemptively addresses the most common justification officers use for stopping recordings, which is the claim of interference. It establishes that the citizen is at a lawful distance and not obstructing anything. And it puts the officer on notice, on the recording itself, that the citizen knows their rights before any escalation occurs. The recording that follows now contains the officer's conduct, the order to stop filming, the citizen's invocation of their First Amendment right, and whatever happens next. Every second of that footage is now potential evidence. Drop a comment right now and tell me, have you ever been told to stop filming by a law enforcement officer and complied without knowing you had a constitutional right to continue? Yes or no? I want to know how many people have backed down from a right the federal courts have already confirmed they have. If you are still here, hit the like button, because what comes next is the critical piece most people miss entirely. What to do immediately after the incident to protect the footage and build the record that actually holds up. Here's what you do in the minutes and hours after an officer forces you to stop filming or attempts to seize your device. Step 1 is to keep the footage. If the officer did not successfully seize your phone, the footage you have is evidence. Do not delete it. Do not edit it. Do not share it on social media in a way that could compromise it as evidence before you have spoken with an attorney. Back it up immediately to cloud storage or a second device so that even if your phone is later seized, the footage exists somewhere the seizure cannot reach. Step 2 is to document the incident in a voice memo recorded immediately after the encounter. Do it before you drive away, before you call anyone, before any details fade. State the date, the time, the location, the officer's name or badge number if you observed it, what you were filming, what the officer said, exactly what words you used in response, and what happened after. This contemporaneous record is more credible in court than a statement given days or weeks later. Step 3 is to understand your rights if the officer attempts to seize your phone. An officer cannot lawfully seize your phone or demand you delete footage without a warrant in most circumstances. The Supreme Court established in Riley v. California in 2014 that police generally need a warrant to search the digital contents of a seized phone. If an officer demands your phone, you say clearly, "I do not consent to a search or seizure of my phone. If you are taking it, I want a receipt, and I want to know the legal basis for the seizure." Then do not physically resist. State your non-consent clearly on the record and let your attorney address the seizure legally. Step 4 is to consult an attorney if your right to record was violated. A First Amendment violation by a government officer acting under color of law gives you a potential civil rights claim under 42 United States Code, Section 1983. Attorneys who handle civil rights cases often take these cases on contingency, meaning you pay nothing unless you win. The documentation you created in steps 1 through 3 is the foundation of that case. Let me tell you about Jerome. Jerome is 29 years old, lives in Pennsylvania, and was standing on a public sidewalk filming a police encounter involving a neighbor when an officer told him to put the phone away or face arrest for obstruction. Jerome lowered the phone. He did not know his rights and had no documentation of anything that occurred. The Third Circuit, which covers Pennsylvania, decided Fields versus City of Philadelphia in 2017 and explicitly held that filming police in public is protected by the First Amendment. Jerome was in exactly the jurisdiction where that right had been most clearly affirmed. A civil rights attorney he later connected with told him what I am telling you now. The officer's order to stop filming was almost certainly a First Amendment violation. The arrest threat compounded it. Jerome had a potential civil rights claim. He could not pursue it because he had no footage, no voice memo, and no record of the officer's badge number. Nothing to stand on in court. Jerome now knows the 4 steps. After this video, so do you. 3 legal foundations make everything in this video exact. Glick versus Kniff, decided by the First Circuit in 2011, was one of the first federal appellate decisions to clearly hold that the First Amendment protects the right to record police officers performing their duties in public. The court said this right is fundamental and beyond debate. Fields versus City of Philadelphia, decided by the Third Circuit in 2017, held that the First and 14th Amendments protect the right to photograph and record police performing their duties in public. The court rejected the argument that recording is only protected if it is accompanied by a specific expressive intent. 42 United States Code Section 1983 provides the legal mechanism for suing government officials who violate constitutional rights while acting under color of law. An officer who orders you to stop filming, seizes your device, or threatens arrest for recording in a public space may be liable under this statute. The documentation you create in the moment is what makes that liability actionable. Here is the complete recap. The First Amendment protects your right to record police performing their duties in public spaces. This right has been affirmed by multiple federal circuits and is not a gray area. An officer who forces you to stop filming may be committing a First Amendment violation. When an officer orders you to stop recording, before the phone lowers, you say this: "Officer, I have a First Amendment right to record police performing their duties in public. I am not interfering with your work. I am at a lawful distance. I am going to continue recording." Then you continue filming. If the officer escalates, you keep the footage, record a voice memo immediately after, state your non-consent clearly if your phone is seized, and consult a civil rights attorney about a potential Section 1983 claim. Think about one person in your life right now, someone who films police encounters on their phone and has been told to stop without knowing the federal courts have already ruled on their right to keep going. Share this video with them today, not later, right now. The statement you just learned takes 10 seconds to say, and it is the difference between footage that ends when an officer says so and footage that becomes the foundation of a case. Next week, I am covering what happens when police knock on your front door, what they can see from the doorstep, what changes the moment you open it, and the exact words you say through a closed door that keep every constitutional protection you have fully intact. Subscribe so you catch it the day it drops. Hit the like button if this changed how you will handle the next time an officer tells you to stop filming. Drop a comment telling me whether you knew before today that multiple federal circuits have explicitly ruled that recording police in public is a First Amendment right. Know your rights, use them, stay safe.